as Virginia kindly said, I've got a long background in working with children with autism and adults with autism, but my work now as a barrister is focused on very much the same client group, but also a wider group of vulnerable people. I mainly represent claimants in applications for judicial review in the High Court, but I also do quite a lot of advisory work for charities, including the NAS and government bodies as well. So the point of this morning's session is to review some of the key recent developments in community care law, and I'm using that in the broadest sense, so effectively anything that isn't education, because I'm going to be covering education later on this morning. I'll jump up.
Steve, can I just mention they are on the tables?
That's great, thanks. So you do have slides on tables in front of you if you want to follow. Okay, so this is the agenda for the morning. While you have your coffee and pastries, and you're all very brave for coming and hearing me talk about the law before 9 o'clock in the morning. I think that deserves a special medal. But if anyone has any questions at any point, please jump in. I think the point of this morning is that it should be interactive, and I'm here to try and answer anything that you might want to ask me about the law in relation to children or adults with autism. So yeah, try me out, see how we get on. 4 topics I would like to talk about. Firstly, the Autism Act and the statutory guidance. Now, I know there was a seminar session about that yesterday. Did anyone go to that session? Very good. So you can tell me what happened there. But the point of this morning, I think, is to look at it from a lawyer's perspective and to try and tease out which bits of the guidance might be enforceable and how they might be enforced. Secondly, I thought we should talk about personalisation and what the law has to say about this rather controversial area of policy and practice. Thirdly, the new short breaks duty for disabled children, which includes, of course, all children with autism. And finally, and perhaps most importantly of all in the current climate, and given the title of this conference, some thoughts as to what the law has to say about challenging cuts to services, both to individual families, but also globally or collectively as well. Some very interesting recent developments. And it says followed by open discussions, but as I said before, I'm happy to take questions at any point. So, the Autism Act, it's a huge success for the autism community as a whole, and it is, as I'm sure you know, the first condition-specific piece of legislation in England. It's an enabling act in legal terms, so its function is to require the strategy to be produced and then guidance to be passed, and it is the guidance that is at the centre of the change that the Autism Act is supposed to create. It's section 3 of the Act, and it says that section says that the guidance is to be treated as a general guidance to the Secretary of State under section 7 of the Local Authority Social Services Act. Section 7 guidance is well known now in social care circles, and the case there, Rickson, tells us that guidance that's passed under section 7 of the 1970 Act has to be followed unless there is good reason not to do so. So this is where the legal force of the guidance comes. And here's a quote from what the judge said in the Rickson case. Parliament, in enacting section 7, did not intend local authorities to whom ministerial guidance was given to be free, having considered it, to take it or leave it. Parliament, by section 7, has required local authorities to follow the path charted by the Secretary of State's guidance, with liberty to deviate from it, where the local authority judges on admissible grounds that there is good reason to do so, but without the freedom to take a substantially different course. So that is a very long-winded way of saying it must be followed, have some good reason not to do so. And importantly, and very innovatively, I was very surprised to see this. Under section 3, subsection 3 of the Act, NHS bodies are to be treated as if they are local authorities for the purposes of the Act. And that's how Parliament got round the problem of the tradition we have in this country of not binding the NHS, with guidance. So just specifically for the purposes of the Autism Act and the guidance, an NHS body is a local authority. And it works. It's a rather curious way of doing it, but it works. And it mainly means that the guidance has the same force and the same applicability, the same enforceability in relation to primary care trusts and strategic health authorities. One important gap is that an NHS Foundation Trust is not an NHS body for the purposes of this Act. So that a lot of hospitals are now run by foundation trusts, and the guidance itself makes clear that they are not bound by it. They have to have regard to it, but it will be easier for them to justify not following the guidance than it would be for a body that is formally captured by the Act.
Can I ask a question?
Of course.
Working in the PCT, you're about to move to a social enterprise.
Right. Well, as you know, I'm sure you know very well, the whole of the health landscape is being transformed by the current bill. PCTs will be, in short order, abolished. There will be GP commissioning consortia and the new NHS commissioning board. So we won't have strategic health authorities or PCTs for much longer. Inevitably, then the Act will have to be amended so that the new bodies are caught by it. Big question, will both GP consortia and the NHS boards be caught? There should be, but we'll have to see what Parliament does. At the moment, as long as a PCT remains a PCT in law, it will be caught by the guidance. If it abolishes itself and constructs itself as another type of organisation, then it may not be strictly caught by the guidance. However, I don't think you can. You might be able to reconfigure yourself into a social enterprise or some other kind of vehicle, but you'll still be, in law, a PCT. At the moment, there has to be a PCT in every area at the moment. So I think the real challenge will be what happens once the new Health and Social Care Bill becomes law. But the guidance says clearly that the expectation is that GP commissioning consortia will be caught. So it should be as before. I'm happy to talk more about the changes in health, which are obviously very challenging, and people want to ask about that. So the short answer is all public bodies except for hospital trusts are required to follow the guidance without unless there's good reason not to do so. Now, very helpfully, one of the questions that's at the forefront of people's minds at the moment is not having enough money good reason not to follow the guidance. Now, the guidance says it's not, or says it's unlikely to be. Let's find the relevant passage. Here we go. Page 6 of the guidance. I'll just quickly read out what it says. In the context of introducing the duty to follow the guidance, it says if they, i.e. local authorities and NHS bodies, do not follow the guidance and cannot provide a good reason, they may be liable to judicial review. Lack of sufficient resource would not necessarily constitute a good reason. Not necessarily. So the question is left open, but the thrust of all the case law is that good reason not to follow statutory guidance is that you think you've got a better way of achieving the same outcome. No one's ever, to my knowledge, run a defence in a court case that says we agree that this would be a good thing to do, but we can't afford it. Inevitably, someone will try that at some point in the next year, 18 months, and the courts will make a determination. But the current position is that good reasons not to follow guidance are supposed to be because you can achieve at least as good a result by a different way. Of course.
Is it not that the legislator wants us to know that we have to make our priorities right?
The guidance is...
The money we have not to make the biggest of mistakes.
The guidance does help set priorities and should steer the way the money is spent. But it's also very clear that it's part of a localism approach, where local areas are supposed to decide for themselves what the priority is. So one of the themes of the guidance is that it's not as strict or as binding as to precisely what has to happen as it might be. And as, for example, the nearest comparator, which is the deaf blindness guidance, that guidance is much clearer about specific obligations and specific duties in relation to individuals who have dual sensory impairment than the autism guidance is about individuals with autism. And that reflects when it was produced, because the blindness guidance was produced under the Labour government that was still setting very clear central targets, whereas the current government is committed to much more local prioritisation. So, yes to an extent is the short answer to your question. That's the full title, which I'm sure people are now aware of. And I've just trotted through some of the requirements of the guidance. Now, as an initial point, being lawyers, we get very engaged by specific language. And one of the key questions that we will always ask is the language mandatory or is it permissive? Does the language require something to happen or does it just allow something to happen? And the autism guidance goes down the middle because mandatory language in Acts of Parliament and guidance is must and shall, and permissive language is may, basically. And the autism guidance uses should. Now, I can only assume that that's very deliberate because the lawyers have gone through this with a fine-tooth comb, and the point of that must be to try and square the circle between giving local areas freedom and recognising there has to be some central direction. Now, my view, my personal view, is that in the context of the guidance and reading it in the context of the Act, and the point of the guidance is to secure the implementation of the strategy. So that's the purpose of it. To secure the implementation of the strategy. My view is that should is effectively the same as must or shall, and that it is effectively mandatory. But I can guarantee that there will be local authorities or PCTs who will say, we don't accept that. We say that it's merely a recommendation that we can choose or not to follow. So I'm afraid that's another issue that's almost certainly going to need to be resolved in the courts. And you can see some of the specific shoulds here on this slide. So local areas should develop specialist training for professionals. Community care assessments should be carried out by trained practitioners, but a very unhelpful bit of wriggle room is given in page 17, which is as far as possible. So there's a double opt-out there. Now, I think it's very difficult, even without the guidance and without the Autism Act, for a local authority to justify community care assessments of adults with autism being conducted by people who don't have sufficient training. That's very close to irrationality an approach. So, whether that wiggle room will actually help if the challenge is made to community care assessments being carried out by people without sufficient training is another question. And in any event, what we would do as lawyers is review the outcome of the assessment and say, well, does that relate to the person's needs? And if it's been conducted by someone who isn't trained, it's hard to see how that could happen. So that's problematic. The next point, Roman numeral 3, each area should put in place a clear diagnostic pathway reviewed against the NICE guidelines. Now that's important, so I should say 2012, not 2010. But NICE is producing guidelines on adult diagnosis and a number of other issues. And so once those guidelines are out, the guidance says each area has to review its diagnostic pathway, assuming it has one by then, and ensure that it reflects what NICE has called for. So that's potentially quite helpful. There's a useful section on page 17 around the role of NHS bodies, health professionals, referring adults with autism to social services for community care assessments. That's genuinely helpful in my view, because it's another should obligation, but they should refer with permission for an assessment, so we don't end up with that very lengthy gap that we often see now between diagnosis and any kind of positive intervention from the social care side. Every area should appoint a lead professional for diagnosis and assessment. Again, that's useful. Autism-specific health services should not be overlooked. I think that rather understates the case. The whole of the section where that extract comes from, there's 4 sections in the guidance, and this is, I think, section 2, yes, B, which is about identification and diagnosis leading to assessment of needs. It's very much focused on the role of social services in providing support to adults with autism. And then at the very end, we get a final bullet point that says there may also be a need for autism-specific health services following diagnosis. It's important that these are not overlooked. That's it. And I don't think that's clear enough in any way, certainly for us to rely on in court, but more importantly still, for people in practice to know what is expected. So that's a gap, in my view. The section on transition is very much about reminding bodies of their existing obligations, and that's a thing that comes through the guidance. Most of what's in here isn't new. There's some useful, clear statements, like the fact that adults with autism are eligible for community care assessments, but that's been the case since the 1990 Act was passed. So really what the guidance is doing generally is nailing down the fact that adults with autism are eligible for support and services as other people who have needs for social care support are. And that's very much the case on transition, because the reminder is that there should be an SEN review at the age of 14, and that's mandatory for children with statements, optional for children without. Critically important and frequently overlooked, and it's frequently overlooked that there has to be multi-agency engagement in the Year 9 annual review. But there's also helpful references to health action plans, which are not a mandatory requirement but are at least good practice, which would be a transition plan on the health side. And also Section 139A assessments. Now that used to be assessments carried out under Section 140 of the Learning and Skills Act. It's been reconfigured so now Section 139A. And this is, again, very poorly understood at the moment, but a very important duty, which is to assess children's needs in their last year of school where they have a statement. And there's also a power to do it where the child doesn't have a statement. And then develop a plan that shows what the positive outcome is going to be for them once they leave school, further education, training and so on. There have been a couple of important recent cases which nail on that the assessment has to go into detail about the child's needs, and the plan has to be specific and specify which provision is going to be suitable for the child, and then funding should follow. So that's a duty that is very important, poorly understood at the moment, and helpfully reflected in the guidance. Guidance goes on to say something that's genuinely useful. The transition plans should be individually tailored and updated each year, which again, very rarely happens in practice. There should be mental health transition protocols in place, and there should be a named joint senior commissioner for transition and local commissioning plans. Now, all of those planning obligations are enforceable, in my view, by any young person, family in the area. So if there wasn't, for example, a mental health transition protocol, any young person with Asperger's syndrome or autism would be eligible for legal aid and entitled to bring a judicial review application challenging the failure to put in place a protocol. And of course would potentially require a protocol to be put in place within a specified period. So these planning obligations are not just good practice. If I'm right that should means must, then they are duties that have to be complied with. So, coming on to this point of this morning, as opposed to the overall implementation session yesterday, the guidance says at page 8 that services must improve to better meet the needs of adults with autism. It is not sufficient to simply carry on with the status quo, and local areas should be accountable for the way they respond to this guidance. Now, the main way that areas will be made accountable is that, as I've said, on an application for judicial review by any affected individual, family or local group. The test for judicial review standing, the test for being able to bring a claim, is very wide. Anyone who has a real interest can do so. And so local areas need to ensure that they have properly considered the guidance and adapted their processes and changed their services to reflect what it says, because it's in force immediately. So there's no time lag on this. So at least in theory, if an adult with autism or a family or a local group are dissatisfied about something that the guidance says should be happening and isn't happening, they could bring a claim now. Now, it may well be a defence which is we're working on it, but that defence will only be available for a relatively short period of time. So I think that the message in terms of professionals, practitioners, commissioners, managers, is that the guidance does create obligations, almost certainly, and that to avoid unnecessary and expensive legal challenges, the best way to deal with that is to comply with what the guidance says, or construct your good reason not to do so at the earliest possible stage, and try and avoid that reason being you can't afford it. So otherwise, my view is it's more likely than not court won't accept that. Any questions about the guidance? At the moment, almost all adults and children with autism, in fact, and going forwards, that will be the case as well. There's two issues. Are you financially eligible for legal aid? And then is the area of law that you're concerned with within scope for legal aid? Now, financial eligibility has been reduced down and down So effectively it means that you have to be on benefits and have no income and very, very little savings. And after changes that are happening shortly, that threshold will be slightly lower again. So if an adult with autism isn't working, as sadly so few are, they will be eligible for legal aid. And almost all children will be eligible for legal aid unless they have a trust fund in their own name. So families can get legal aid even if the parents are working or have fairly significant sums of their own in the name of the child or the adult that's in the family. And it's quite it's something people don't understand, I think, and again, perhaps a reason why relatively few channels abroad is that the legal aid availability in this area is much greater than it will be in other areas. The gentleman just in the back of that.
Well, one of the difficulties introduced by valuing people was to specifically exclude Asperger's syndrome from being a learning disability. Does the Autism Act go any way to counteract that? Because as it is at the moment, me as a GP have an obligation to provide a particular examination for all the patients that I have with a learning disability on an annual basis. They get an annual checkup.
Yes.
So it specifically at the moment excludes people with Asperger's syndrome.
No, you're absolutely right, and the guidance doesn't change that. What it does make crystal clear, and this is the legal position, is that IQ, for example, cannot be used as a criterion to exclude people from services, and that's on page 15. And in general terms, including for health, the law requires individual assessments and decisions to be made about what people need based on an assessment of the individual. And what Valuing People does for learning disability, for the checkup, is it creates an entitlement that's based on the diagnosis. That doesn't undermine the fact that other groups may also have health needs that have to be addressed. So Valuing People commits and requires something for a particular group. It doesn't exclude others from getting a service that meets their needs. And in fact, under the Equality Act, GPs and all other public bodies have to make reasonable adjustments to services that have to avoid discrimination that arises from disability. And the guidance gives some useful examples around amending waiting arrangements for people with autism, which is a classic issue. But if there was a person with Asperger's syndrome who had clear health needs and those needs weren't being addressed, then it would almost certainly be a reasonable adjustment to have an annual checkup for that person. So I don't think we should be treating Valuing People as in some way excluding individuals with high-functioning autism or Asperger's syndrome from services. It is designed to require something for people with learning disabilities.
The practical problem I have is that in France, by law, and it will be short, by law, parents are required, are allowed to give their advice on school choices. And it's not a ministerial literary, it's a law. But it's not the reality. But the problem I have is that in France, it's just hopeless to be defended in the court when you are on benefits, because the lawyers are just not good enough and not spending time enough. I'm sorry to say that, but it's a painful experience. So could you sincerely say that if you have not the money to pay good lawyers, and it costs a lot, you will be on the right road to take legal action with that money?
Well, the short answer is yes, I can say that here, and I appreciate that in France it's very different. But the legal aid system in the UK is still, despite all the attacks on it, one of the most generous in the world. And myself and approximately 100 colleagues in my chambers and possibly 1,000 colleagues in the bar generally do publicly funded work almost exclusively in areas involving vulnerable people. And you know, I won't be able to say whether people think that I'm doing a good job. I need my clients to say that. But the outcomes from the case,
many great
the outcome from the cases. I think the point that I would make is, and I've got a plug here. This is the book on disabled children's law that I produced with Luke Clements and Janet Reed last year in October. And I'll leave a copy at the front if you want to have a look. It's all of it's on free of charge at the Council for Disabled Children website. It's called Disabled Children: A Legal Handbook. And you can get copies from Amazon or from all good bookshops, in fact. The reason I plug it there is because it's full of cases that have been taken on behalf of disabled children and indeed young people and adults. And yeah, there's a book that Luke Clements wrote that's 4 times the size. It's about the law on adults. Sure. It's Disabled Children: A Legal Handbook. Perhaps my assistant here can help. Thank you very much.
You just have to hope in France that you will go to the European courts.
Well, exactly. I'm afraid the French legal aid system is outside of my my knowledge or competence. You certainly can go to the European courts, indeed. Anyway, I'm very conscious of the time, so what time do we need to finish? Anyone know? 9:15 is the next session, I think, isn't it? So we'll make sure we're finished by 9:10. Personalisation. Luke Clements, whose name's on the book, and many of you will know, wrote a wonderful paper called Individual Budgets and Irrational Exuberance. And what Luke was trying to do there, and I fully endorse his efforts, is highlight that the whole edifice of personalisation, the whole approach of personalisation, is a castle built on sand. There's no law underpinning any of it at all. And in fact, the legal obligations on community care are as they were, in essence, when the 1990 Act was passed. The only real change has been direct payments in the 2001 Act. So the only legal underpinning for personalised approaches is the direct payments system. Individual budgets and personal budgets do not exist in law. They're policy constructs. Now, there's nothing wrong with that. What is problematic, in my view, is that the personalisation agenda builds in cuts to people's care packages. There is a built-in deflator in all of the RAS and resource allocation systems that is designed to promote efficiencies. And the challenge I have as a lawyer, the question I want to ask is, how can you show at the end of a RAS process that the outcome, the amount of money that's being allocated, there's any rational connection to the assessment of the person's needs? Because the duties of law, there's 3 duties. It's as simple as that. You assess, you decide whether the person's eligible, and if they're eligible, you provide everything that they need. All of their eligible needs must be met. We've known that since the case of Farron in 1997. So, the paper that was produced by some of the advocates of personalisation is called Don't Get Fooled by the Law. I turn the question round and say don't get fooled by personalisation, because the legal duties remain absolutely, in essence, as they were. And this was reconfirmed by the prioritising need guidance, which has replaced fair access to care services, and which makes it crystal clear that even if you're going to adopt a resource allocation system approach and convert people's needs, assess needs into a financial sum, you have to be able to demonstrate how that allocation of money meets needs. And the key case is now Sava, which I've mentioned on the slide. It was a case against Kensington and Chelsea, and it went to the Courts of Appeal. And in Sava there was a disabled woman who was unhappy with the amount of money that was allocated to her by Kensington and Chelsea. And through applying their RAS scheme, if I remember rightly, there were 3 different financial sums produced. And no reasons were ever given, or no substantial reasons were ever given as to why any of those amounts of money were sufficient to provide her with the services that she had been assessed as needing. Now, Kensington and Chelsea's RAS survived the challenge. So the policy was upheld by the court as, and that's the important point, a starting point. And so there was nothing wrong with using a RAS scheme to create an indicative amount of money. But what was impermissible was to then say, and that's your lot. There has to be a moderation process at the very least, when you go back to the community care assessment and determine that the sum is sufficient to meet the needs. Now that, of course, requires that there's been a community care assessment in the first place. Some of the schemes don't actually have in them anymore a proper community care assessment. All there is a self-assessment questionnaire, FAQ. The prioritising need guidance alone says that that's unlawful. So in any lawful personalised system, there still has to be a community care assessment when the social worker assesses needs based on any input they like to take from the person themselves, including an SAQ. But the social worker has to assess needs and decide whether the person's eligible and which needs are eligible. And then at the end, there has to be a correlation between those needs and the amount of money that's being given. And we know that from the direct payments guidance, because the duty under the direct payments guidance is to provide a reasonable sum to secure the provision of the necessary services. So this is all crystal clear, and any authority that tries to deviate from that approach is going to certainly find itself in court, because these duties have to be upheld. They're at the basis of the scheme.